Welcome, everybody, to today's episode of The Law of Self-Defense. I am, of course, attorney Andrew Branca for Self-Defense. This is an on-the-road July 4th weekend, not in the office broadcast. Actually, it's pre-recorded. So when I say I am attorney Andrew Branca for Law of Self-Defense and you don't hear the automated applause, that is your cue to replicate that automated applause, the canned applause, on my behalf. Thank you so much. Thank you so much. I can't believe all the support I get from all you generous people. At least some of you provide support. This is an open access broadcast. It'll be streamed on YouTube, Rumble, Twitter, and of course to our Law Self-Defense members, but in a pre-recorded format. So I will not be taking live questions at the end as I do on my usual live broadcast. And today we're here to talk about a Tennessee State Supreme Court decision from a few years ago, 2017, that came across my desk, and I thought it was interesting enough, covered enough interesting topics, legal doctrines, that it would be a useful exercise for us to do a breakdown, a distillation of this decision in a Law of Self-Defense show. So without further ado, let me launch right into the show proper. And we're back to talk about the Tennessee State Supreme Court decision of State v. Perrier. Before we do, I should mention, of course, that we are sponsored by none other than Law of Self-Defense itself. I know not all of you are Law of Self-Defense members, but you ought to be. And the good news is you can try out Law of Self-Defense membership for just 99 cents. For 2 full weeks, unlimited access to our thousands of blog posts, video legal analysis, podcast legal analysis. It's a negative risk proposition, folks. If you don't like it in that 2 weeks, we will refund you 200% of your money. And if you stay a member, and virtually everybody does, it's still dirt cheap, only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member. You'd be crazy not to try it out. Much, much more than 60% of our content is members only. What you see on YouTube or Rumble or Twitter is a small fraction of what we produce every week. Plus, the only questions we answer in any show are those posted by Law of Self-Defense members in the Law of Self-Defense chat. That's the only place we look for questions and comments. So, with that out of the way, let's jump right into this decision, because I don't want to waste our time on this lovely 4th of July weekend. Let me blow that up a bit. So this involves a shooting at a convenience store. The court does a good job of stepping through the facts of the case and then the various legal arguments of the case. So I'm going to jump right into the decision and read the relevant portions. I'll skip over the legalese and the internal citations. And, of course, I'll add my own commentary and analysis at appropriate points throughout. So here we go. State v. Perrier, Tennessee Supreme Court, 2017, and a decision handed down just before the end of the year, November 21st, 2017. We have the various legal counsel there. For the appellant, Antoine Perrier, who, of course, was the defendant at trial, is the appellant on appeal, and then the many, many state prosecutors who served on this appeal, and of course the judges as well. We have a 1, 2, 3, 4, 5, 6, 7, I believe. Let me count this better. 1, 2, 5. Looks like 5 justices on this panel. And the author of the decision was Justice Robert A. Page. So, diving right into the decision, the court writes, "We granted the defendant's application for permission to appeal in this case with direction to the parties to particularly address the following issues. 1, the meaning of the phrase, not engaged in unlawful activity, in the self-defense statute of Tennessee, 3911-611, which is Tennessee's core self-defense statute. And 2, whether the trial court or the jury decides whether the defendant was engaged in unlawful activity. We hold, spoiler, the conclusion of this decision, we hold that the legislature intended the phrase not engaged in unlawful activity in the self-defense statute to be a condition of the statutory privilege not to retreat. Strangely, they only give half the holding. So they're answering question 1 here in the spoiler, but not answering question 2, which is a bit odd, but we'll come back to that. Partial sentence. We hold the legislature intended the phrase not engaged in unlawful activity in self-defense statute to be a condition of the statutory privilege not to retreat when confronted with unlawful force. And here's the answer to part 2, and that the trial court should make the threshold determination of whether the defendant was engaged in unlawful activity when he used force in an alleged self-defense situation. So whether or not the defendant's engaged in unlawful activity is to be determined by the trial judge, not by the jury. So 2 questions here. What does being engaged in unlawful activity cost the defendant? Does it cost the defendant merely the legal privilege to stand their ground? In other words, is that only a condition to stand your ground, that you don't have a legal duty to retreat in otherwise lawful cases of self-defense? Or is not engaged in unlawful activity a condition of self-defense generally? So if you're found to have engaged in unlawful activity, do you lose not just your stand your ground privilege, but the entirety of your self-defense claim? You might be surprised, but the truth is you only lose stand your ground privilege. You don't lose self-defense generally. And that's typical in virtually all states, not all states, but in virtually all states. You don't automatically lose your privilege of self-defense simply because you're engaged in unlawful activity. Not being engaged in unlawful activity is not generally one of the elements of self-defense. So to illustrate, a street corner drug dealer is obviously engaged in unlawful activity. But if he's the victim of an armed robbery, and street corner drug dealers are often the victims of armed robberies, after all, they have cash and drugs, what could be better? If they're the victim of an armed robbery, they're allowed to use deadly force to defend themselves against an armed robbery. They're still on the hook for the drug dealing, but they haven't lost the privilege of self-defense because they happened to have been engaged in street corner drug dealing and illegal activity when they defended themselves against the armed robbery. Now, what they will have lost under this decision is not self-defense generally, but the stand your ground privilege in particular. Remember, stand your ground addresses one of the 5 elements of self-defense, the element of avoidance, whether or not there's a generalized legal duty to retreat before you can use deadly force in self-defense. Many states, especially the states that have a statutory stand your ground privilege, condition that privilege. So stand your ground relieves you of that otherwise existing generalized legal duty to retreat before you can use deadly force in self-defense. Many states, especially the statutory stand your ground states, have as a condition of qualifying for stand your ground that you were not engaged in unlawful activity at the time. If you were engaged in unlawful activity at the time, you don't lose self-defense generally, but you do lose stand your ground, meaning you've reacquired that element of avoidance. So without stand your ground, well, with stand your ground, you have 4 elements of your claim of self-defense: innocence, imminence, proportionality, and reasonableness. The element of avoidance, the 5th element, is waived if you qualify for stand your ground. But if you fail to qualify for stand your ground because you were engaged in unlawful activity, for example, you regain that element of avoidance and you've regained a generalized legal duty to retreat before you can use deadly force in self-defense, if it's safely possible to do that. So that's one question. What does being engaged in unlawful activity lose you? Does it lose you self-defense generally or just stand your ground privilege? The court here is saying it loses you only stand your ground privilege, not self-defense generally. The other question is, who decides whether you were engaged in unlawful activity? Is this a finding of law that's done by the judge, by the court? Or is this a finding of fact that's done by the jury? Now, personally, I would think this would be a finding of fact, but in the spoiler here, we have the Tennessee Supreme Court holding that we further conclude that the defendant's conduct in this, The trial court should make the threshold determination of whether the defendant was engaged in unlawful activity when he used force in alleged self-defense. We further conclude that the defendant's conduct in this case constituted unlawful activity for the purpose of this statute as a matter of law. They're making a matter of law finding. Remember, a matter of fact finding would be for the jury at trial. The defendant has also presented 4 other issues to this court, arguing that the trial court erred by failing to properly instruct a jury on lesser included offenses, that the second count of the indictment was deficient, that the trial court should have given the jury an instruction on the defense of necessity, and that the evidence was insufficient to support the defendant's conviction for assault. We affirm the judgments of the trial court and the Court of Criminal Appeals, the mid-level appellate courts, albeit on separate grounds. Opinion. So this is the core of the opinion. We're past the introduction, the facts of the case. On February 13th, 2010, the defendant fired a weapon at men standing in front of a convenience store, and he struck a young girl standing inside the store, an innocent bystander. The defendant was indicted in November 2010 for attempted second-degree murder. By the way, just note the time span here. So the event and the indictment took place in 2010. This appeal from the Tennessee Supreme Court, the ruling is handed down in 2017. So it's 17 years later. Now, the defendant didn't get any relief here. But even if he had, what if they had reversed his conviction? Decided, you know what, the trial was all wrong. The mid-level court of appeals was all wrong. This person should never have been convicted. You're free to go. The best possible outcome you could get from an appellate court. He still spent 17 years in jail, in prison. The defendant was indicted in November 2010 for attempted second-degree murder, employing a firearm during the commission of a dangerous felony, and 6 counts of aggravated assault. His trial was held in February 2011, so pretty quick, 4 months. And he was convicted of attempted voluntary manslaughter as a lesser included offense of second-degree murder, of attempted second-degree murder, employing a firearm during the commission of a dangerous felony, 5 counts of aggravated assault, and 1 count of assault as a lesser included offense of aggravated assault. He was sentenced to an effective sentence of 30 years in the Tennessee Department of Correction. At the defendant's trial, several of the victims named in the indictment testified, as well as the defendant and a female friend of the defendant who witnessed the shooting. The witnesses agreed that between 3 p.m. and 4 p.m. on February 13th, 2010, the defendant and his female friend, Faith Taylor, visited the Miracles Mini Market in Memphis, Tennessee to buy alcohol, of course. That another customer at the store, Anthony Vassar, oogled Ms. Taylor, and that subsequently Anthony Vassar and his brother, Tion Vassar, exchanged words with the defendant outside. The witnesses disagreed as to the intensity of that exchange, but the result of the exchange was that the defendant, standing next to Ms. Taylor's vehicle, drew a loaded handgun from his jacket and shot toward the front door of the market, where Anthony Vassar, Tion Vassar, and Anthony Vassar's son were standing. Several bullets passed through Tion Vassar's clothing. The bullet struck an 8-year-old girl in her hand and grazed her stomach and leg. The defendant submitted that he acted in self-defense based on Tion Vassar's motions. The police did not find any weapons when they searched Tion Vassar. The defendant admitted that he had been previously convicted of a felony, so a felon in possession of a firearm now. The defendant's original motion for new trial was filed late, as was the notice of appeal. The Court of Criminal Appeals waived the late filed notice, but because of the late filed motion for new trial, it only considered sufficiency of the evidence and sentencing, ultimately affirming his conviction. The trial court granted the defendant a delayed appeal. In his second appeal, the defendant claimed that the trial court's jury instruction on self-defense was erroneous, that the trial court committed plain error by failing to include a jury instruction on possession of a firearm during the commission of a dangerous felony as a lesser included offense of employment of a firearm during the commission of a dangerous felony, that the indictment for employment of a firearm was void for failing to name the predicate felony. These are all technicalities. Let's see if we get to something more interesting. let's see, here we go. The defendant filed an application for permission to appeal to this court, the Tennessee Supreme Court. And in granting review, this court ordered that the following issues be addressed by the parties. 1, should the trial court make a determination of whether the defendant was engaged in unlawful activity before charging the jury on self-defense, or is the question of whether a defendant was engaged in unlawful activity a determination to be made by the jury? Interestingly enough, the courts reversed the sequence of the two questions here from earlier. So this first question is, who decides if the defendant was engaged in unlawful activity at the time of self-defense? Does the court decide, or does the jury decide? If the court decides, it would decide before it instructed the jury, gave the jury instructions. If the jury decides, it would be one of the instructions that the court gave to the jury. So who decides? The second question is, what is the effect of that decision? So if it's determined the defendant was engaged in unlawful activity, does he lose self-defense generally? He has no privilege of self-defense, or does he only lose the stand your ground privilege, the removal of the element of avoidance from the 5 elements of self-defense? So there's only 4 targets of attack left for the prosecutor: innocence, imminence, proportionality, and reasonableness. Now we get into the analysis. The defendant asserted a claim of self-defense at trial. The Tennessee Code, section 3911-611B, provides the statutory basis for the defense. Notwithstanding some other provision, a person who's not engaged in unlawful activity and is in a place where the person has a right to be has no duty to retreat before threatening or using force against another person when and to the degree the person reasonably believes the force is immediately necessary to protect against the other's use or attempted use of unlawful force. Then we get to the deadly force section of the statute. A person who's not engaged in unlawful activity and is in a place where the person has a right to be has no duty to retreat before threatening or using force intended or likely to cause death or serious bodily injury if, and now we have the additional conditions required for deadly defensive force. If A, the person has a reasonable belief that there is an imminent danger of death or serious bodily injury. B, the danger creating the belief of imminent death or serious bodily injury is real or honestly believed to be real at the time. And C, the belief of danger is founded upon reasonable grounds. So what do we have here? We have proportionality. Before you can use deadly defensive force, you have to believe there was a danger of death or serious bodily injury. We have imminence, that the threat of death or serious bodily injury was an imminent threat, that this was honestly believed, subjectively believed, or real, and the belief, that subjective belief, is founded upon reasonable grounds. So it's objectively reasonable. Then the element of avoidance is dealt with by no duty to retreat. And all of this is prefaced by not engage in unlawful activity. So that's why we get to the question, does not engage in unlawful activity impact only the no duty to retreat? Or is it a condition of all of this? All of this. That's the question raised before the court. The trial judge provided a self-defense instruction to the jury, but he added to the pattern, the standard instruction, by giving examples of what might constitute unlawful activity. The following is a self-defense instruction given by the trial judge in this case, with additions to the standardized instruction italicized. Did I italicize it? Yes, I did. Okay. So here's the self-defense, deadly force self-defense jury instruction. If a defendant was not engaged in unlawful activity and was in a place where he or she had a right to be, he or she would have no duty to retreat before threatening or using force against the alleged victim when and to the degree the defendant reasonably believed the force was immediately necessary to protect against the alleged victim's use or attempted use of unlawful force. So that first paragraph is essentially the non-deadly defensive force instruction. Now we get to the deadly force. Deadly defensive force instruction. If a defendant was not engaged in unlawful activity and was in a place where he or she had a right to be, he or she would also have no duty to retreat before threatening or using force intended or likely to cause death or serious bodily injury if A, the defendant had a reasonable belief that there was an imminent danger of death or serious bodily injury. B, the danger creating the belief of imminent death or serious bodily injury was real or honestly believed to be real. And C, the belief of danger was founded upon reasonable grounds. Let's see. So the next paragraph talks about how you can consider the circumstances in their totality. I'm not going to dive into all of that. You can read it at your leisure if you like by pausing. Continuing, the use of force against the alleged victim would not have been justified if the defendant provoked the alleged victim's use or attempted use of unlawful force, unless the defendant abandoned the encounter or clearly communicated the intent to do so, and the alleged victim nevertheless continued or attempted to use unlawful force against the defendant. So this paragraph goes to the element of innocence. If you provoked, started the fight, you can't claim self-defense unless you withdraw and communicate, thereby regain your element of innocence, regain self-defense. This defense of self-defense is not available to the defendant if the victim was an innocent third person. So you use force defensively, you fire a defensive round, you injure an innocent bystander. You can't claim self-defense for that if the injury caused was recklessness. If it was not reckless, if it was genuine self-defense, it's a different question. But here, this defense of self-defense is not available to the defendant if the victim was an innocent third person who was recklessly injured or recklessly killed by the defendant's use of force. Recklessly has previously been defined. We all know what that is, right? Recklessness is when you deliberately create an unjustified risk of death to others, knowingly ignore that risk, and then the harm results. Here's the emphasized part, the italicized part of the instruction to which this Tennessee Supreme Court is going to refer in detail. Whether a defendant was engaged in unlawful activity at the time he is claiming self-defense is a question for the jury's determination. It is a violation of federal law and unlawful for any person who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year, meaning a felony, to ship or transport or to possess in commerce and firearm or ammunition, or to receive any firearm or ammunition which has been shipped or transported in interstate commerce. It is a violation of federal law and unlawful for any person to receive or possess a firearm which is not registered to him in the National Firearms Registration and Transfer Record. It is a violation of state law and unlawful for a person who's been convicted of a felony to possess a handgun. In order to establish a violation of this provision, the state would have to prove beyond a reasonable doubt that the defendant has been convicted of a felony, that the defendant after such felony conviction possessed a handgun, and that the defendant acted either intentionally, knowingly, or recklessly. See, that really makes it sound to me like that's a question the jury should be answering, not the judge. Continuing, it is a violation of state law for a person to unlawfully carry a weapon with intent to go armed. In order to establish a violation of this provision, the state would have to prove beyond a reasonable doubt that the defendant carried a firearm, that the defendant did so with intent to go armed, and that the defendant acted intentionally, knowingly, or recklessly. A person who has been convicted of a felony offense is ineligible to obtain a handgun carry permit. That's the end of the italics. Then we have definitions of force, of violence, of imminent, of serious bodily injury. Continuing, if evidence is introduced supporting self-defense, the burden is on the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. Meaning, once the defense has met their burden of production on the legal defense of self-defense, the burden shifts to the state to have to disprove self-defense beyond a reasonable doubt, meaning disprove any one of the required elements beyond a reasonable doubt. Continuing, if from all the facts and circumstances you find the defendant acted in self-defense, or if you have a reasonable doubt as to whether the defendant acted in self-defense, you must find him not guilty. Standard of review. So this is, what's the threshold the court here, the Tennessee Supreme Court, should use in evaluating these questions? Remember, we have thresholds of proof, like preponderance of the evidence, clear and convincing evidence, beyond a reasonable doubt. We also have thresholds of standard of review. Some of them are lower or higher. The decision reads, the primary issue in this case concerned the trial court's jury instructions on self-defense and the construction of this state's self-defense statute. By the way, the italicized part of the jury instruction I just read is what the trial judge added to the jury instruction, his custom edition. We have standard pattern jury instructions approved by the state Supreme Court because that's the instruction the state Supreme Court wants the trial courts to use. If you begin to modify, alter, amend the approved standardized jury instructions, that's about the easiest way for a trial court to get reversed on appeal. After all, the state Supreme Court told you how to say it to the jury, and you decided to say it in a different way. Makes you very vulnerable as a trial judge to reversal on appeal. So, the primary issues in this case concern the trial court's jury instructions on self-defense and the construction of this state's self-defense statute, meaning construction interpretation. As issues involving statutory construction present questions of law, we review such questions de novo with no presumption of correctness. So the other biggest standard of review is abuse of discretion. So under the abuse of discretion standard, the appellate court is saying, look, if there's any rational basis for these judges' ruling at trial, even if we would have made a different decision, we're going to defer to the trial judge. It has to be completely insane that the trial judge made that decision. If that happened, we'll call it an abuse of discretion and we'll overrule the trial judge. But generally, abuse of discretion standard means you're not going to get a reversal on that point. Here, the Supreme Court's doing something else. It's saying we're going to review such questions de novo with no presumption of correctness. De novo means new. It means that this Tennessee Supreme Court is giving no deference to the trial court on this question. It is asking the question anew, as if the question were being presented to the Tennessee Supreme Court for the first time, and their call on the question is what will be controlling. Continuing, this case also requires us to interpret the self-defense statute. When engaging in statutory interpretation, well-defined precepts or guidelines apply. The most basic principle of statutory construction is to ascertain and give effect to the legislative intent without unduly restricting or expanding a statute's coverage beyond its intended scope. Historical review of self-defense law in Tennessee. Excuse me, folks. Historical review of self-defense law in Tennessee. Prior to 1989, self-defense was a matter of common law in Tennessee rather than statutory law. By the way, that's still true in Massachusetts to this day. You look up self-defense law in Massachusetts statute, you won't find any. You'll find a Castle Doctrine reference, that's about it. But there is no self-defense statute in Massachusetts. All the self-defense law, defense of others law, defense of property law is really found in Massachusetts court decisions, case law. And before 1989, that was the case in Tennessee as well. Also, prior to 1989, the law on self-defense included the duty to retreat. Quoting now from a court decision, Tennessee Supreme Court decision from 1980, quote, also well established in the law of excusable homicide is the requirement that the slayer must have employed all means in his power, consistent with his own safety, to avoid danger and avert the necessity of taking another's life, close quote. This court recognized a limited exception to the duty to retreat when a person is acting in defense of one's home or habitation. That's really what's called the Castle Doctrine. That's the proper definition of Castle Doctrine. However, the General Assembly codified the law on self-defense in 1989 and specifically included a provision that eliminated the duty to retreat. Quoting now from another Tennessee Supreme Court decision, which in turn quotes from the Tennessee Self-Defense Statute, 1989. The statute is 3911-611. The year of the statute is 1989. Quote, In 1989, the General Assembly added a no duty to retreat rule to the law of self-defense. This legislation, which is now codified in Tennessee Code, provides a person is justified in threatening or using force against another person when and to the degree the person reasonably believes the force is immediately necessary to protect against the other's use of unlawful force. There is no duty to retreat before a person threatens or uses force. Close quote. In 2007, the General Assembly rewrote the self-defense statute. So if we look at the stand your ground here, there's no reference here in the 1989 version to not being engaged in unlawful activity. There's the existing self-defense law of Tennessee. There's the addition of the stand your ground privilege, taking away the element of avoidance as a target of attack for the prosecution. But there's no indication that stand your ground is conditional on not being engaged in unlawful activity. So continuing with the decision, in 2007, the General Assembly, the legislature, rewrote the self-defense statute. The relevant sections now read, a person who is not engaged in unlawful activity and is in a place where the person has a right to be has no duty to retreat before threatening or using force against another person, when and to the degree the person reasonably believes the force is immediately necessary to protect against the other's use of unlawful force. And then the same language is added for the deadly force section of the Tennessee self-defense statute. Next section of this decision, arguments of the parties. The defendant argues that the phrase not engaged in unlawful activity is unclear, but recognizes that the legislative history of the statute does not shed any light on the meaning of the phrase. The defendant contends that the phrase only modifies the duty to retreat and does not apply to the entirety of the law of self-defense. He further argues that the General Assembly intended for there to be a nexus requirement between the defendant's unlawful activity and the defendant's need to assert self-defense. In other words, that the defendant's unlawful activity is what caused him to have to defend himself. Any other construction, according to the defendant, would lead to an absurd result. The state responds that the plain language of the statute does not encompass a causal nexus. Other points on which the parties disagree are whether the trial court or the jury determines if the defendant engaged in unlawful activity and how the self-defense statute interacts with Tennessee Code 3917-1322. I don't know what that is, folks, but perhaps we'll find out in a moment. Duty to retreat. The next section of this decision, Section 5, duty to retreat. Before inquiring into these other matters, we will first consider the defendant's argument that the not engaged in unlawful activity language applies only to whether the defendant had a duty to retreat, as opposed to applying to all of self-defense generally. Again, the pertinent language of the statute is that a person who is not engaged in unlawful activity and is in a place where the person has a right to be has no duty to retreat before threatening or using force. To answer the question of whether the unlawful activity language modifies the entirety of the claim in self-defense or only applies to the no duty to retreat qualification, we must further examine the history and language of the statute, because the statutory language is not clear and is not clear and unambiguous. In fact, this court has previously assumed that the unlawful activity language applied to the defense as a whole. However, in that case, this question was not presented to the court for consideration. On the other hand, in State v. Montgomery, the parties assumed that if the defendant was engaged in unlawful activity, that he would not be excused from the duty to retreat, and the Court of Criminal Appeals accepted this assumption when discussing whether the defendant had in fact been engaged in unlawful activity. The abandonment of the duty to retreat was the primary distinction between the common law and the statutory law of self-defense. The duty to retreat was the focus of both the Kennemore case and the Renner case, the former of which was decided under the common law, and the latter of which was decided under the first iteration of the statutory law on self-defense. The third phrase in the pertinent language, quote, is in a place where the person has a right to be, unquote, is related to the true man doctrine discussed in Renner. The true man doctrine is simply another term for the no duty to retreat rule, and it provides that one does not have to retreat from a threatened attack. Quote, this doctrine applies only, 1, when the defendant is without fault in provoking the confrontation, and 2, when the defendant is in a place where he has a lawful right to be and there is placed in reasonably apparent danger of imminent bodily harm or death. In other words, there's no duty to retreat in an otherwise lawful case of self-defense. The provocation factor is codified in Tennessee Code Annotated 3911-611. The second factor is now the phrase is in a place where a person has a right to be. The relationship between that phrase and the true man, no duty to retreat rule lends credence to the defendant's argument that the not engaged in unlawful activity language only applies to whether a duty to retreat exists. The unlawful activity language is also included in subsection D3 of the self-defense statute. Under subsection D3, the presumption established in subsection C, this would be a legal presumption of reasonableness when you're defending highly defensible property, folks. The presumption established in subsection C for a person defending himself or herself in a residence, business, or vehicle does not apply if the person who used force was engaged in unlawful activity. The presumption is that a person using defensive force in a residence, business, dwelling, vehicle held a reasonable belief of imminent death or serious bodily injury when the defensive force was used against someone who unlawfully and forcibly entered said building or vehicle. Thus, under subsection D3, a person engaged in unlawful activity is not entitled to the legal presumption that his belief of imminent death or serious bodily injury was reasonable under the circumstances. Interpreting not engaged in unlawful activity as used in subsections B1 and B2 as a condition on the privilege to not retreat is consistent with the way engaged in unlawful activity is used as a limitation on the subsection C presumption. In other words, in subsection C, the legal presumption of reasonable fear in the context of defense of highly defensible property, you're not losing the privilege to use defensive force entirely if you were engaged in unlawful activity. You're losing the has no duty to retreat privilege. And the court is saying, well, if that's the only way it could apply to defense of highly defensible property, then that must also be the way it applies to other facets of use of force law, like defense of yourself. Because of that, therefore, taking into consideration the history of the statute, the developments in case law as connected to the principles espoused in the statute, and the language of the statute as a whole, we conclude that the phrase engaged in unlawful activity applies only to a person's duty to retreat and not also to self-defense generally. This interpretation is consistent with other states that have equivalent statutes. I'm not going to read through all of this because I will, by the way, hyperlink this decision in the members only blog post comment area for today's show. So you'll be able to click and download this decision and read it in its entirety at your convenience. But this is the standard rule for stand your ground across the country. The 39 states that have stand your ground, if they do conditions to stand your ground on not being engaged in unlawful activity, the not being engaged in unlawful activity conditions stand your ground, specifically the element of avoidance, but not self-defense generally. Let's see. These are other states, referring to other states. Now, other states' law are not controlling on Tennessee here, but that other esteemed judges have come to certain decisions can guide this court, this Tennessee Supreme Court, on where they perhaps ought to follow the lead of their esteemed colleagues. All right, so that's the question of what does stand your ground affect? what does being engaged in unlawful activity affect? Does it strip away only the stand your ground privilege, or does it cost you self-defense entirely? The answer is it strips you only of the stand your ground privilege, meaning you've reacquired the element of avoidance as a required element of self-defense. The legal duty to retreat from the fight before using deadly defensive force, if you can do so with complete safety. Next, the question is, who makes the decision of whether or not you were engaged in unlawful activity so that you do trigger this event? Does a judge do it, or does a jury do it? So, Section 6, threshold determination and burden of proof. We next address whether the trial court or the jury determines if the defendant has met the conditions for the privilege not to retreat. In Renner, a previous case, this court, the Tennessee Supreme Court, explained that factual issues related to the duty to retreat were jury questions, and that the state could elicit testimony on those issues, such as whether the defendant had a right to be on the premises, for example. However, who determines whether someone was engaged in unlawful activity for purposes of the retreat component of the self-defense statute has not been addressed by this court. The Court of Criminal Appeals has been split on the question of whether the trial court or the jury decides if the defendant engaged in unlawful activity. Some Court of Appeals panels have held that a trial court can decline to give the self-defense instruction entirely based on its determination that the defendant was engaged in unlawful activity, unlawful behavior. Now, the argument there would be, well, if you're engaged in unlawful behavior, you've lost the element of innocence. If you don't have the element of innocence, you don't have self-defense. But really, it seems like a question of fact, not of law. If you decide the fact, then the legal consequence follows, of course. But first, who decides the fact? And normally, that's the role of the jury. Then this court also cites other states, Alabama, a bunch of stuff from Alabama, Arizona. Again, I'm not going to read all these other states. You can look through this decision in the PDF. I'll link into the blog post version of today's show. In these other states, so still talking about other states, concluding within the structure, the trial court makes the threshold determination whether to charge the jury with self-defense. In other words, to give the jury a self-defense jury instruction. And we conclude that the trial court, as part of that threshold determination, should decide whether to charge the jury that a defendant did not have a duty to retreat. As part of that decision, the trial court should consider whether the state has produced clear and convincing evidence that the defendant was engaged in unlawful activity, such that the no duty to retreat instruction would not apply. Because the allegedly unlawful activity will oftentimes be uncharged conduct, similar to evidence of prior bad acts, the procedure outlined in Tennessee Rule of Evidence 404B should be utilized by the parties. So 404B is a rule of evidence. Character evidence is normally not admissible to the jury, but the judge can consider the evidence himself for other purposes. So here, the Tennessee Supreme Court, I've been saying throughout the show that really this seems to me like a question of fact for the jury. The Tennessee Supreme Court is recognizing that the facts of the engaged in illegal conduct may well be facts that are separate from the criminal charge in the case. So, say, for example, you have an armed robber in a convenience store, and he's committing the act of armed robbery, allegedly, and the clerk pulls out his own gun, and the armed robber shoots the clerk dead. Well, there could be two charges there, an armed robbery charge and a murder charge brought against the armed robber. But those charges could be split. So, for example, the evidence about armed robbery may be not that strong. Maybe the defendant is going to say, no, I wasn't robbing the place. That guy owed me money. The clerk owed me money. I went to demand the money, and he pulled out a gun and tried to shoot me. So I pulled out my own gun in self-defense and shot him back. So you could be in a situation where now he's charged with murder for the shooting of the clerk, and he's claiming self-defense, and the trial court would say, well, I want to argue the self-defense independent of the armed robbery charge. So normally, if that were to happen, the evidence of the armed robbery would not be admissible, because if he's not being charged in that trial with armed robbery, but only with murder, then you'd only have evidence relevant to murder being admitted, not evidence relevant to armed robbery. But if the state wanted to argue that, well, he doesn't get stand your ground or even self-defense, arguably, because he was engaged in illegal activity, unlawful activity, to wit, the armed robbery, then the state would be sneaking in the non-permitted armed robbery evidence. So the Tennessee Supreme Court is saying here, it's the better way to do this is not to have the jury listen to the excluded evidence, the prejudicial evidence of the unproved armed robbery, to determine whether or not he was engaged in unlawful activity. Don't let the jury hear that evidence. It's prejudicial, inadmissible to the charge of murder. Instead, so to keep the jury from having to listen to that, we'll have the judge hear that evidence outside the hearing of the jury, and the judge will make a determination of whether or not the defendant was engaged in unlawful activity. And if you decide to what did they say? By a preponderance of the evidence? Clear and convincing evidence. So preponderance is 51%, a little bit more than half. Beyond a reasonable doubt is like 95%. Clear and convincing evidence is somewhere in between those two. So the trial court should consider whether the state has produced clear and convincing evidence that the defendant was engaged in unlawful activity, such that the no duty to retreat instruction would not apply. Because the allegedly unlawful activity will oftentimes be uncharged conduct similar to evidence of prior bad acts, generally that evidence should not be admitted before the jury, the Tennessee Supreme Court is saying here. Application to this case. In this case, as discussed above, the trial court left the determination of whether the defendant was engaged in unlawful activity to the jury, but provided additional guidance on what conduct of the defendant might constitute unlawful activity. Quote, it is well settled in Tennessee that a defendant has a right to a correct and complete charge of the law, meaning jury instruction, so that each issue of fact raised by the evidence will be submitted to the jury on proper instructions. Therefore, trial courts have a duty to give a complete charge of the law applicable to the facts of the case. A complete charge, a complete jury instruction of the law. Questions regarding the propriety of jury instructions are mixed questions of law and fact. Thus, our standard of review is de novo, with no presumption of correctness. So it's not an abuse of discretion standard. Quote, an instruction should be considered prejudicially erroneous only if the jury instruction, when read as a whole, fails to fairly submit the legal question or misleads the jury as to the applicable law. Close quote. Based on our holding above that a defendant's engagement in unlawful activity for the purpose of the self-defense statute is a threshold determination to be made by the trial court, the trial court's jury instructions in this case were erroneous. However, the state contends that the instructions were harmless beyond a reasonable doubt, while the defendant argues that the instructions were prejudicially erroneous because under the instructions, his illegal possession of a weapon could have been considered engaging in unlawful activity by the jury. This, he claims, gutted his self-defense strategy because even if the jury believed he was justified in firing his weapon, they would not be able to acquit him under the self-defense theory because he did not retreat when he had a duty to do so. He also claims that the instructions were incomplete because the trial court failed to instruct the jury that any unlawful activity must have had a causal nexus to his need to defend himself. Meaning, there's a difference between the street corner drug dealer scenario I described earlier, where he's suddenly subject to an armed robbery. His illegal activity is selling drugs, and then suddenly he's a victim of an armed robbery. That's a different scenario than when your illegal activity is you walk into a liquor store and point a gun at the clerk. The pointing of the gun at the clerk directly leads to the clerk's response with defensive force, right? That's not the case in the armed robbery scenario. There's much less of a causal nexus between the drug dealing and finding yourself at the point of a gun, and committing an armed robbery and finding yourself at the point of a gun. Continuing now with the opinion, considering whether the defendant's possession of a firearm when he was a convicted felon amounted to engaging in unlawful activity, we hold that this conduct is encompassed within unlawful activity. The defendant points to the language at the beginning of each relevant subsection of the self-defense statute, the non-deadly force subsection and the deadly force subsection, notwithstanding 3917-1322 as support for his argument, maintaining that the legislature did not intend for possession, display, or employment of handguns to ever be the unlawful activity that would require the defendant to retreat before using defensive force. So there is a footnote here. That Tennessee Code section 3917-1322 provides a defense to prosecution for weapons violations when a person used a handgun in justifiable self-defense. So 3917-1322 has a provision that says, if you're in unlawful possession of a gun, you can be charged with the crime of being in unlawful possession of a gun, except you can't be charged with unlawful possession of the gun if the reason you were in possession of the gun was self-defense. And here the defendant is claiming, no, that was a carve-out intended to mean that you could never use illegal possession of a gun against me in a self-defense context. Continuing now. We note that the common law duty to retreat required that the slayer must have employed all means in his power consistent with his own safety to avoid danger and avert the necessity of taking another's life. Thus, a duty to retreat does not mean that a person cannot defend himself or herself or himself. A defendant may still defend himself even to the point of using deadly force, as Code Section 3917-1322 makes clear, may be acquitted of a weapons offense if a jury finds that his self-defense was justifiable. These provisions are not mutually exclusive. In this case, there was clear and convincing evidence at trial that the defendant had a felony conviction and that he possessed a handgun. Thus, as a matter of law, he was engaged in unlawful activity. The defendant maintains that any unlawful activity by a defendant asserting self-defense must have a causal nexus to his perceived need to defend himself. The state responds that the statutory language does not admit a reading that includes a causal nexus. It is unnecessary to resolve this issue to decide the case before us. We conclude that under the facts of this case, the trial court's error in instructing the jury was harmless beyond a reasonable doubt because no reasonable jury would have accepted the defendant's self-defense theory. The evidence showed that any belief on the defendant's part that he was in imminent danger of death or serious bodily injury was not reasonable, considering the testimony by multiple witnesses that only words had been exchanged and that no one had used or attempted to use unlawful force on the defendant. So even if it were true, this court is saying that Tennessee statute 3917-1322, even if it were true that it meant that having a gun unlawfully, but in an act of self-defense, was not being engaged in unlawful activity, even if that were true, it doesn't matter because the condition of being engaged in self-defense doesn't apply here because the defendant's claim of self-defense was so pathetic that no reasonable jury could have believed it. I'm not going to cover the lesser included offenses here. That's nitty-gritty detail. Adequate notice of underlying felony. I'm not going to do that. There is an interesting necessity argument here, and I think we'll wrap up with that. So that's section D now of this decision, necessity. Remember, the necessity defense is sometimes called the doctrine of lesser evils or the doctrine of competing harms. It generally holds that it can be excusable to commit some small crime, some small harm, in order to avoid a much greater harm. And the example I often use is there's a baby locked in a hot car. It's locked. You can't find the owner. No one else. There's no way to retrieve the baby from the car so that it won't die. It will inevitably die if you don't rescue the baby from the car. The only way to rescue the baby is to break the window of the car, unlock the door, retrieve the baby, save its life. Is breaking the window of the car a crime? Sure, it's criminal mischief. It's destruction of property, whatever. But it's a small harm relative to the large harm that was avoided, the death of the baby. It's a balancing test between two harms. The defendant argues that the trial court should have granted his request to instruct the jury on the defense of necessity. The state responds that because the harm sought to be avoided was not greater than the harm caused by the defendant's conduct, the trial court properly denied the defendant's requested instruction. So what was the harm caused by the defendant? A near killing, right? It was attempted murder. So an infliction of deadly force upon another person. In this case, an innocent victim, the little girl. That's the harm that was caused. What was the harm to be avoided? The death of the defendant would be the defendant's position. So the defendant's argument is, look, I almost killed that bystander, but I didn't actually kill her, and I was seeking to avoid my actual death. So I committed a small harm, the almost death of the bystander, to avoid a bigger harm, what would have been my actual death. I generally don't see the applicability of the doctrine of necessity to the context of the loss of human life, because in the eyes of the court and the system, they don't really distinguish. They don't place more value on the defendant's life than they do the life of the bystander. It's human life and human life. That's not a balancing of different values. Those are the same value. And if the values are the same, there's no necessity defense. But continuing with the court decision, whether the trial court properly instructed the jury on a certain offense is a mixed question of law and fact, which requires de novo review with no presumption of correctness. So no deference to abuse of discretion by the trial court here. Necessity is a general defense that must be submitted to the jury if it is fairly raised by the proof, by the evidence. To determine whether a general defense has been fairly raised by the proof, a court must consider the evidence in the light most favorable to the defendant and draw all reasonable inferences in the defendant's favor. The defense of necessity is available when a defendant reasonably believes the conduct is immediately necessary to avoid imminent harm, and when the desirability and urgency of avoiding the harm clearly outweigh the harm sought to be prevented by the law prescribing the conduct according to the ordinary standards of reasonableness. That's just that balancing test. The Sentencing Commission comments to this section state in full, quote, "This section codifies the common law defense of necessity. It excuses criminal liability in those exceedingly rare situations where criminal activity is an objectively reasonable response to an extreme situation. For example, the necessity defense would bar a trespass conviction for a hiker stranded in a snowstorm who spends the night in a vacant cabin rather than risking death sleeping in the open. The defense is limited to situations, one, where the defendant acts upon a reasonable belief that the action is necessary to avoid harm, and two, where the harm sought to be avoided is clearly greater than the harm caused by the criminal act. The defense is further limited in application to those offenses where it is not expressly excluded by statute. Subdivisions 1 and 2 contemplate a balancing between the harm caused by the conduct constituting an offense and the harm the defendant sought to avoid by the conduct. If the harm sought to be avoided was, by ordinary standards of reasonableness, clearly greater than the harm actually caused, the defendant's conduct causing the offense is justified." Close quote. The trial court in this case determined that the harm sought to be avoided was not greater than the harm actually caused. We agree. Even if one of the Vassar brothers had been threatening to shoot the defendant, which they weren't, they had no guns, his firing toward the convenience store where 3 people were outside and at least 3 people were inside was a far greater harm. Therefore, considering the evidence in the light most favorable to the defendant, the proof did not fairly raise the defense of necessity. Then they have an argument based on sufficiency of the evidence. It's a rather technical argument. Sufficiency and weight of the evidence are two different things. I'll describe them briefly, but I'm not going to go into this in depth because we've been going for an hour already, and it is July 4th weekend. Weight of the evidence is an argument that to the appellate court that no reasonable jury could have concluded that the weight of the state's evidence sufficiently overcame the defense that the crime was proven beyond a reasonable doubt. So it's a weighing of the evidence between the state and the defense. So there's evidence on every element of the crime, and then the defense has raised counter evidence, counter arguments to the state. And was the weight of the state's evidence sufficient to prove the crime, each and every element of the crime beyond a reasonable doubt, when weighed against the counter arguments of the defense? So again, it's a balancing. A sufficiency of the evidence argument is a different argument for the appellate courts. In a sufficiency argument, you're not weighing, you're not balancing the state's evidence against the defense evidence. In fact, you're not considering the defense evidence at all. What you're saying is, even if the defense had not said a word, had introduced no evidence, made no argument, the state's evidence, even considered in isolation, was technically insufficient to lead a reasonable jury to a finding of guilt beyond a reasonable doubt. How might that happen? Well, many crimes, most crimes, have multiple elements. Say there's 4 elements to a crime. The state's burden is to prove each and every one of those elements beyond a reasonable doubt. So say the state introduced evidence beyond a reasonable doubt for element 1, element 2, element 3, but they forgot to introduce any evidence against element 4. Well, if they did that, element 4 cannot have been disproven beyond a reasonable doubt. And so technically, the state's body of evidence is technically insufficient from a technical perspective to prove the crime beyond a reasonable doubt, because they cannot prove each and every element beyond a reasonable doubt because they forgot to introduce evidence against one of the required elements. So in that case, the state's case standing alone without even looking at defense arguments or evidence is insufficient. That's an insufficiency of the evidence argument. But I'll spoiler, this Tennessee Supreme Court does not buy that argument in this case. So conclusion, we conclude that the legislature intended the phrase "not engage in unlawful activity" in the self-defense statute to be a condition of the statutory privilege not to retreat when confronted with unlawful force. So a condition of stand your ground. We further, not of self-defense generally. We further conclude that the trial court bears the initial responsibility to determine whether the defendant was engaged in unlawful behavior when he used force in an alleged self-defense situation. We hold that the defendant's conduct in this case of being a felon in possession of a firearm was unlawful activity as a matter of law, but that the trial court's jury instructions were harmless error. Furthermore, the defendant is without relief regarding his remaining issues. In sum, we affirm the judgment of the trial court and the Court of Criminal Appeals, albeit on separate grounds, separate reasons than they gave, for the issue regarding the interpretation of the self-defense statute. And that's it. They affirmed the decision below, but based on different reasoning than what was used below. Robert A. Page, Justice, authored this opinion. And there we have it, folks. A bunch of law, self-defense, legal doctrine, and other legal doctrines like weight of the evidence, sufficiency of the evidence, review de novo versus review based on abuse of discretion. A lot of generalized criminal law, legal doctrines covered in this case, which is why, in the context of a use of force trial, which is why I wanted to share it with all of you. So with that out of the way, again, I will have a PDF hyperlink of this decision in the blog post version of today's content. Of course, the video of this will also be there, as well as on the members only podcast and the open access podcast. So with all of that out of the way, I want to thank you for spending a little bit of your 4th of July weekend with me, about an hour. And now I will release you to the hamburgers, hot dogs, beer, fireworks, all that great stuff for you to spend with your family and your friends, which is what I'll be doing shortly. All right, folks, until next time, remember, if you carry a gun, so you're hard to kill, that's why I carry a gun. So I'm hard to kill, so my family is hard to kill. Then you also owe it to your friends and your family to make sure you know the law, so you're hard to convict. Until next time, stay safe, have a great 4th of July, and I remain Attorney Andrew Branca for Law.